Hello, I'm Lis Wiehl, and I'll be your host this afternoon on Law and Crime. Now, we're on a break in the Jeffrey Willis case in Michigan. The jury is on a break for a few minutes, and so we're going to be talking about it. And in studio with me today, I'm very happy to have my guest, Kenney Badan, who I've known for many years, a wonderful friend of mine, and much more than that, she is a former prosecutor. You know her well. She's been on many, many famous and infamous cases, I may say, or maybe your clients have been infamous. Maybe that's just my view, not yours, of course. And we have many things to talk about. And of course, you're the perfect guest to have here in this alleged serial murderer. There seem to be a lot of serial murderers around these days.
I'm getting the chills. I said, oh my God, I think Jack the Ripper is turning over his grave. He's no longer famous or infamous, as you would say.
It's true.
Oh my gosh.
There's so many of them. Anyway, so we have Jeffrey on the stand, and we had the openings earlier this morning, and we'll talk more about that in a minute. And on the stand now, or just had on the stand before the break, the lead investigator who sort of set the case and set the tone for the case. And of course, as we know, that's what the prosecution does after their opening. They usually put the lead investigator on to kind of set the roadmap for the jury, kind of say, you know, this is what happened, this is what I did, here's what you're going to be hearing about from the witnesses, if there are any witnesses in a serial murder case, and this is what I found. How do you think the prosecution is doing so far?
Oh, in this case, it's a slam dunk. I mean, they're showing how they got the car. They saw a silver SUV going away. He's talking about the detective, how he talked to the car manufacturer and got the VIN numbers, and they whittled them down from 1,000. It just showed their commitment, and we already know. I mean, this is terrifying. The jury heard in openings, which the viewers are now going to listen to.
Right.
Terrifying. I was terrified, and I wasn't even there.
Right. I wonder in a case like this, this is going to sound, I don't know, but I'll just say it, almost what's the point from the defendant's point of view? I mean, why even do this? To save himself the death penalty from a serial murder point of view? That's it? Right.
That's
Linda,
it.
this is just a slow plead, isn't it?
The whole case is about whether or not there's a death penalty. That's it. It's Clarence Darrow and Leopold and Loeb from the 1920s. That's all this is about. Nothing more, nothing less.
Okay. All right. So in other words, get the death penalty off the table, humanize him to a point where even a death penalty qualified jury, and by that I mean a jury who has said, look, we will, if we find him guilty, we are willing to say we would put him to death. That's what I mean by death penalty qualified. But they will have gotten to know him and not like him, obviously, but know him well enough that he's not just, you know, a name on a docket, but know him well enough that they can't put him to death.
And that's it. And you know, it's not an unreasonable position this way. I'm Catholic. The Catholic Church believes that everybody has a value. So they are anti-abortion, they're anti-death penalty. So if you get a juror with one of those feelings, that juror could save his life. Now, unfortunately for the defense, they are a death-qualified jury, so they said they could impose a death penalty. But, oh my gosh. Hard case.
Right. Okay. All right. Well, we're going to take a look at a sort of a preview of this trial, and let's set that up for our viewers, and then we'll come back and talk some more about this, Linda. I'm so glad you're going to be here with me this afternoon, because this is you're the best guest to have on a kind of an awful case, but you're the best guest to have here.
Thank you, Lisa.
The trial of convicted serial killer Jeffrey Willis is scheduled to begin this week. Willis, who was convicted in late 2017 for the 2014 murder of Rebecca Blech, is accused of the kidnapping and murder of Jessica Haringa. Willis was arrested in connection with the Blech and Haringa murders after a teenage girl who escaped her abductor identified Willis as her captor. Police later searched his home and van and charged him with the unsolved murders. Prosecutors contend Willis schemed to abduct women so he could rape, torture, and murder them. Willis is currently serving a life sentence for the Blech murder and is awaiting trial for the abduction of a teenage girl. For Law and Crime, I'm Rachel Stockman.
Now that gave you a preview, an overview of the case. Really horrific facts. I mean, right, Linda?
It's
just
terrible because, you know, you can't go anywhere and not feel threatened, and that's what's terrible about this. These women are, the fear that these women had, the fear is something that we can feel. We can feel here now, years later, sitting in a studio far away, and just to put them, yourselves, and the jurors are going to put themselves in the women's shoes. They are. They can't avoid it.
Exactly.
And it's very, very hard to look at that person and not think that, what ability does he have to do anything for society unless we want to study serial murderers, which some people say that's a value. Now,
taking it from the prosecutor's point of view here for a second, we discussed a moment ago before we heard the preview that from the defense perspective, this is a long guilty plea, that the whole point is to try to take the death penalty off the table. From the prosecutor's point of view, they know that that's what the defense is doing. From the prosecutor's point of view, is this, they have nothing really to bargain with here. There is no plea to really bargain with, right?
Right.
They can't take that. They can't give that to them and say, plead straight up and we'll take death penalty off the table, because the victims' families, I would assume that they've been, you know, talking with the victims' families, and they have just said, no, you know, don't take that off the table. That's what I would have done as a prosecutor.
That's right. You're absolutely right. The one thing you have going for you for defense attorney, if the victims' families are against the death penalty, then there may be, if as a defense attorney, you may say some hope. And also the prosecutor doesn't want to go against the family of the victim. But the problem here is you have more than one victim. So even if one family didn't, you have another. And then you have the girl who was kidnapped. And so, you know, you don't ever want him to get back out on the street. Never, ever. Off the table. No doubt. And the prosecutor has to be careful, but they don't want to make any mistakes, because every death penalty case is subject to a very high scrutiny and review. And so any little thing can reverse the verdict, and they have to come back. So they want to make no mistakes.
Okay, now you've just brought up something that's very interesting, though, because at that point, is there what the prosecutor could be dealing with? I'm not saying in this case, but in some cases, a plea has a lot greater chance of surviving an appeal, because, quite frankly, there's a lot less you can screw up. There's a lot less room to screw up a guilty plea, because what happens in a guilty plea is the defendant, you draw up the papers between the prosecution and the defense stands up in front of the judge and pretty much just reads what the parties have agreed to, and the judge says, do you agree with this? And the defense says, the defendant says yes. And that's pretty much it. The judge goes through, you know, do you agree with this, this, and this? And the judge, the defendant writes off on it, and that's it.
And you go directly to jail. Do not pass go.
Do not pass go. Do not collect $200. That is it.
Right.
With a trial, as we both know, both of them been trial lawyers, you still are, that there are so many things that can be reversed on error. So the prosecution opens themselves up to error, and that is litigated and litigated and litigated. And of course, in a death penalty case, as we know, and they can go on for years and years and years.
Right.
It looks like we've got the jury back in the Willis case. So let's go back live and take a peek at what is going on in the Willis case. And we're back with Linda and myself when there's a break in the action. But here we go. Let's go back and. So we're back here in the case of Mr. Willis, and it looks like they've got another investigator on here, Mr. Flowers, Detective Flowers. And it looks, Linda Badan, as if they're presenting a safe of some sort. They're going through quite a lot of look at that. There's quite a lot of investigative work to be able to show the jury what they've got there. Looks like handcuffs. And oh my gosh, look at that. There's certainly chains, things like that would show sexually motivated kidnapping. Remember, that's what Willis is being charged with here. Linda, what do you make of this? Look at this. Ties. Oh my gosh.
I don't even know what some of this is.
Yeah, some of this is battery.
Thank you.
Yeah.
Thank you. Because I really don't know. But interestingly enough,
ball and chain almost.
You see, they have to show this is connected to the defendant. So one way they're doing
Otherwise,
it
wouldn't be relevant.
Well, it's not relevant. So probably that box that they're taking time to show the jury must have contained some of this sexual equipment that they want to show the jury where it was found, and that box was belonging to Jeffrey Willis.
Right. Let's listen in. Linda, would you be slowing this down a little bit, because the detective is bringing these things out, showing these chains and sexual, sexual items that we are even trying to explain and explore and try to figure out. Would you be slowing this down for the jury?
Yes, and the reason why, Lis, is that when the women who were getting killed, they were subjected to being this stuff, you know, and so you want to feel the horror that they were feeling, so you want to slow it down and explain like what a ball gag is, and put it in the mouth, someone how it's used, someone can't breathe, someone can't yell, so I would slow it down as a matter of tactics. Right,
and you could even, once it's introduced and presented to evidence like that, you could even, with the judge's permission, different courts are different, you could even actually have the jury physically touch some of this
if they want to.
But you can get real up close and personal.
But look
my
at this.
My worry about some of this is it's going so fast that it almost anesthetizes, which is weird when you're talking about some of this horrible stuff, the jury, because it's going so quickly.
Yeah, and look, he's got drugs, he's got a picture of an injection site. What does that do but to incapacitate the victims here?
And this is coming from his car, and there's a gun there, a handgun.
I mean, when he turned around and looked at us, and in one of the, was going to break before, I turned to you and I said, I'm scared with this guy.
Just looking at him.
It was an eerie, his eyes were dead. And to see all this stuff connected with him, I mean, these poor women, and certainly he's on trial now for the one woman that he's killed here. He's already been convicted of another.
Right.
But the fear.
Yeah. So, Linda, they have this Detective Flowers on the stand going through the toolbox that was found in Willis's vehicle. I mean, excruciating detail about what's found in there. And we both think that he should have slowed down, the prosecution should have slowed down, and for the jury and really define more what's in that toolbox. Some of these sexual toys is kind of a strange word for it, because it's just, much more gross than that. But going through all those things. But I want to go back with you in our discussion we had earlier about the death penalty. And we talked about the death penalty being one of the reasons that, you would, if you were defense, you would go and you would actually have this trial. But that's not the case here in Michigan, where they don't have the death penalty. So why in the heck would a defendant, without death penalty being on the table, go ahead and go through the excruciating detail of having all of this stuff? This is just this toolbox. I mean, there's a lot worse that's going to be going forward in this trial.
Right. Now, from the prosecution side, obviously, because we know that the jury doesn't, but he's already been convicted of one case, they want to have another conviction in case something happens with that first conviction, it gets overturned. But with the defense, so what do you say, why doesn't he just plead guilty since he's already in jail? Well, again, number one, we don't know whether or not that conviction is going to be overturned. Secondly, look, he's got nothing to lose. Maybe this jury will find that he's not guilty. So if
just
he
takes one.
Just takes one, or hangs. So if he pleads guilty, that avenue is gone. Right. So what does he have to lose? He can just sit there and say
not going anywhere else right now, just sitting in prison anyway.
That's it. So I understand where the prosecution is coming from. The defense, that can be the only thing they're talking about, because they're certainly not going to be talking about any type of penalty, because whatever he gets, if he's convicted, it's getting the max, and it's going to run consecutive to his first sentence.
Right. Now, and I introduced you as a prosecutor, but you've also been a defense attorney in very, very high-profile cases. And as a defense attorney, you really kind of have to, at the bottom line, if a defendant doesn't want to take a plea, even though you can, advise for taking a plea, you can say, this is, I think, the best route for you. I think you should take the plea deal. If they don't want to,
you're not going there, because there's only several decisions that a defendant can make. Defense attorneys are in charge of all strategy. But the one, actually there's three of them. The decision is whether or not you are going to plead guilty.
Right.
That's your decision a defendant can only make. Whether or not you have a jury, trial, or judge, that can be made only by the defendant, and whether or not you testify. So those are the only three decisions that a defendant can make in a trial, but whether you plead guilty or not is one you can't force. If he says, I'm not going to plead guilty, now we don't know that, but if he said, I'm not pleading guilty, that's it, you're going to trial.
Right. No matter what.
No matter what. No matter how much the evidence is, whether there's video of it, whether there's eyewitnesses of it. It could be done in the middle of a MetLife Stadium in New Jersey, in the middle of a football game, and if there's witnesses, it's not going anywhere. He is going to trial.
Okay. It looked at one point when this detective was going through the toolbox and going through things that the defendant, Willis, was almost, sort of talking to his lawyers and kind of almost like telling them, like, well, they got this wrong or that wrong, or sort of looking over and like making comments about it. How did you feel about that? It was almost strange, wasn't it?
He was correcting them on what evidence number it was. No, it's 125. It's not 124. It's not 126. It's 125. So it goes to show, I mean, he is in charge. He's involved. He's in charge. But it also kind of was creepy to me because, I've sat next to a lot of defendants, many of whom I have liked, and they've never exerted that kind of like stare that said, this is the way it was. And that's the feeling I got. And if you're a jury, you're watching him. You're watching every single move he makes. And wow.
Okay. All right. Well, looks like we're going to go right back and let's dip right back into the trial. And we'll be back more, Linda, with more commentary from us. But let's go back to the trial, the Willis trial right now in Michigan. Well, now they're doing a little bit of housekeeping, sort of literally here, Linda, as they get rid of the chains and things. It's just got to be strange because they're doing this all in the presence of the jury as they take all of this. I mean, it's a ton of stuff. I mean, that's a lot of things. And we learned about ball gags and everything like that he used. This was all, remember all this, this was taken all from a search of his vehicle. Then there was a very short cross-examination after Linda and I finished talking. There was a short cross-examination, and Linda noted that he was speaking, the defendant was speaking with his counsel at one point. What did you make of that?
Right. Just what we were talking before, when we were interjected beforehand. He stood up, the defendant stood up, he went right into his counsel's ear and wanted him to make some kind of point. Now, yes.
During cross-examination.
During cross-examination. Yes, your client should be involved. Yes, they should be involved with you. But you can see that he is controlling, and it's that kind of controlling that the jury's going to say, well, he was using that against the woman. He really has to be in control. It was scary to me, Lis. I mean, it's eerie to me.
It's one thing to do it in a courtroom like that where he stands up and he's, all dressed up and he's looking nice, and it's very controlled as a courtroom with a judge and a jury and all the, accoutrement of a courtroom. But imagine those women confronted with all of that stuff, horrible stuff that we saw.
And the chains. You see the chains and the
right.
We sugarcoat it by housekeeping it, but it really was terrible because he's putting back and he lifts the chains and the syringes and everything.
And he has that. He has that control. It's not like in those nice little baggies and all bundled up by Detective Flowers and all of that. When it happened that time, when he had it and he was in control and he was doing that to these poor women.
Right.
I mean.
Right.
I hope that picture is, well, it's not really being driven home right now to the jurors in a really horrible way. I'm sure it will be later when the prosecution has it, certainly for closing. Now that it's been introduced into evidence, the prosecution will be able to do what they want with it for closing arguments.
Right. And then just so you could say just the time that you saw it here, and just imagine if you were in a closed space with him and kidnapped and be subjected to that, the fear that the women were in, and that it was all owned by this man here, this defendant.
Right. Okay. All right. Looks like we have another witness on the stand. It looks like Sheriff Peterson with the Sheriff's Department on the stand. Let's go to him. It's an interesting shot there, Linda, of the defendant there with his counsel. As we've been talking about, he is very much, Willis is very involved with his counsel. It looks like he's directing this, which really goes to your point earlier that you said we've all sort of been befuddled about why a guy who is already convicted of murder, already in prison, ostensibly for life, why we would be electing to go through this again. And look, I mean, I think maybe our answer might be exactly what we're seeing right there, is that he is so involved, and he's talking to his defense, and he's telling them about, it's, it looks like it could be this this exhibit or that exhibit, and he's involved in their cross-examination. I have rarely, Linda, chime in here in a minute, I have rarely seen a defendant stand up during a cross-examination of a state witness who is a government witness, an investigator at this point, and stand up and help them out in their cross-examination.
I'm not sure how much he's helping them out, but you're absolutely right. I'm even surprised when he stood up. When normally when you have a client who's already in prison and they stand up in the courtroom, but the officers in the courtroom, whether they're bailiffs or sheriff's officers or corrections officers, they're standing up too. And maybe they were, and we just didn't see it, because he is totally involved, and he is totally a control freak. I mean, that's my read if I am a juror right now sitting there, and I am a juror. I'm a juror over here.
We're all jurors, all watching this
right now.
Exactly, on Law&Crime.
But they also had all those needles, Lis.
Yes,
and
let's talk about that. What about insulin, Linda? What was going on there? Let's talk about that. Can insulin at that level make someone pass out? Is that a method that he was using? Is that what the prosecution is showing here? Is that a method that he was using to incapacitate these women, or a woman in this case? Is that what they're trying to show here?
Well, interestingly enough, you bring your personal experiences as a juror. So as I'm sitting here as the 13th juror here, I had a dog who actually died of diabetes over a period of time. But that was the whole point when we had to give him insulin shots. We also had to have Caro syrup online, because if you give him too much insulin, he could pass out and he could possibly die. So you had to give him sugar if you overdosed him in some way. Now that never happened with my dog, obviously. But here he has so many needles and so much insulin. There's no indication he needs it. So what was he using it for except to control the people that he has kidnapped? And remember, in many states you even need a prescription to get hypodermic needles.
Right, hypodermic needles. Right,
now, obviously, he had a gun and all sorts of other stuff.
But he had this.
But he had this. He obviously went out of his way to get this stuff.
Right. And you said the key word, too, here was control. It's all about a measure of control. We're seeing the control while he's with his defense lawyers, the way he's trying to control them. We're seeing here with the evidence here that's being brought out, the insulin, the ability to control, certainly in the measure of guns. Obviously, that's the way to control people, but in a different way with the chains and the insulin, a different way of controlling these women in such a scary and horrible way that he's accused of doing.
And obviously, since the prosecution's contended these are sexually motivated, he is getting some kind of sexual satisfaction from the control, and he just can't help himself with the control. It is there. It is obvious. It can't be hidden. And I honestly have never seen a client this so much controlling in a courtroom.
Right, and standing up and doing that. And look at his face here. He's just like, he's talking, he's involved, he's looking back and forth. Sometimes they sort of stare away, or they're just not looking, they're looking down or looking around, but he's just staring intently. And very, very much a part of this. He doesn't look like he's been drugged or anything like that. He's taking notes in large measure. Interestingly enough, obviously Michigan allows the cameras to be on him too. We were allowed to see his face, not the jury obviously, but we're allowed to see the defense face and see his expression. And of course, as you know, at least one of the jurors, maybe probably many more, but at least one of the jurors is always watching the defendant, always watching to see what his expression is as all of this stuff is brought out. And many jurors, I would think, Linda, are having some of the same reaction that we are upon seeing some of this evidence, which is, what is that?
I know.
Seeing that, what? And then sort of thinking, Oh, was that what it be used for? To gag somebody and keep her quiet while you were doing horrible things?
Too. And, I'm always aware when I try cases, because usually there is a camera on me, and
Right.
I'm usually seated next to a defendant. I'm aware of every single move that I do. And you watch the defense attorneys here, they're not happy being there. You can just see that they're not embracing their client.
Yeah. And sometimes literally they do embrace their client.
Yes.
Right. But no, they're not. They're keeping their distance. And I noticed when he went up to actually talk with him and advise his defense counsel on cross-examination, the defense counsel did not look too pleased with that. All right. Well, thank you, Linda. Let's go back. We'll come back to us in a few minutes, but let's go back and see what is happening with the state's witness on the stand now, with more of the evidence coming in. So, Linda, the prosecution is doing a good job of painstakingly going through the evidence with the law enforcement officers, the detectives, the sheriff's officers, going through and finding what they found both in his home, in his car, in his shed, all the way through what the insulin we've talked about, the hard drive that they found, all the things they've gone through. Cross-examinations tried to poke a few little holes, but I don't think they've made much leeway, do you?
No, because the whole point about the color, and again, we take our experiences as a juror into that jury room, into seeing the evidence, hearing the evidence. Yes, could you take a picture of a Sony camera bag and it's actually green and it looks black? Absolutely. And I was telling you, Lis, I took a picture behind the scenes. Bob has posted it, Bob Bianchi, who was on beforehand, of him getting his picture taken, and sure enough, he was wearing a, and people can't see this, I don't know if he can, it's, besides handsome Bob, a red and blue tie.
Doesn't he look great?
Okay, look good. But if you go to the other camera, you see Bob looks like he's wearing, and again, they may not be able to see this, a green and purple tie.
Right.
So when you take a photograph, it comes out different depending on lighting and all sorts of stuff, and jurors know that. So I don't know.
They bring their common sense.
Right. They're trying to say that the Sony camera bag was swapped. It's not really the evidence. I don't know, because the point wasn't then made. Now, obviously, there's a lot of things that go into trial. The defense attorney has a good reason that he's asking that question. We may not know what may not see it right now, but there obviously is a reason. But when you look at it just right now, in that vacuum, it didn't look like they were poking any holes.
Okay, let's bring another thing in now, in context here. We know that this is not Willis's first trial. Not his first time at this rodeo.
Right.
That he has been tried before and convicted of murder. In that trial, he did take the stand, which is sometimes, a bit unusual.
Huh?
Right. And he said, nope, wasn't there, wasn't me, didn't do it.
Wow is right.
Wow. Was convicted. Okay. What does that tell you about what he might do in this trial?
Well, remember, one of the three things the defendant can do,
yes, let's go back to that, yes,
is they can decide whether they have a judge or jury trial, they can decide whether they're going to plead guilty or go to trial, and they can decide whether to testify. Those are the three decisions.
Right.
He clearly wanted to testify and assert his innocence. Now, obviously, the defense was somebody else had to do it. Did he point the finger in the other trial at the cousin or somebody else? I don't know. But obviously, it's going to tell me that he is going to take the trial in this case, and there are going to be fireworks. But you know what happens? When this happens, when defendants take the stand, it only comes down to them. It doesn't come down to any other evidence in the case. It just comes down to them.
Believability, credibility of the defendant.
That's it. Whether they like him or not, whether they believe him or not. So it'd be interesting if he testified, but you see that controlling aspect in him, whether he's guilty or not guilty. He wants to control, and he wants to control those jurors.
He's got a lot of explaining to do, though.
Ooh.
How do you explain away? And this is just the first day.
I know.
This is just opening.
The ball gag under your seat, in a box under your seat with a gun and insulin.
Okay.
And
Okay. The ball gag. You can say, all right. It's not
the chains,
what we do, but
and the handcuffs.
But okay. The insulin, though.
The insulin is control.
I mean, how do you?
Unless he's got a family member that is a diabetic, and then he can explain it in some way. But there was an awful lot of it and a lot of needles. Now, yes, do you buy A month's worth of supply of needles, sure. But if there's nobody else, and
he's going to take the stand and say that,
and the insulin wasn't by prescription, and somehow he got it. So I don't know. We don't know how he got it because we don't know yet.
And the 911 call.
And then there's a 911 call.
Right.
With the girl who, and then the cops finding his SUV by going through 1,000 different SUVs. Wow. There's a lot of explaining here to do. Now, yeah, he doesn't bear the burden of proof,
Nope.
but we know,
Right.
but we know that even though a defendant doesn't bear the burden of proof, they sort of do. They sort of do because the jury has to believe the story that's being told.
Once they take the stand.
Once they take the stand.
Right.
Once they take the
he
stand.
doesn't have to take the stand.
Right.
But once he takes that stand and he puts it on himself to say, I'm going to tell you a different story than what the prosecution has said.
Right.
I'm going to tell you what really happened, which
Or
was
that I
didn't
wasn't
do
there.
it.
I
wasn't there. I didn't do it.
Yeah.
Then
I couldn't be at the crime because I wasn't there.
Exactly.
Yeah.
It was somebody else. I don't know who it was. I don't have the burden of telling you who it was.
Right.
But it wasn't me.
So it's interesting because that whole dynamic about reasonable doubt and the burden of proof doesn't really shift, but it does.
Right.
And defense attorneys are very well aware of that. You know, your story has to be believable. That's why, no matter, even when you have the most innocent client in the world, you generally don't put them on the stand because you don't want it to be about them, about the jury assessing just them. You want it to be the jury assessing the prosecution's burden of proof.
Yeah, that scared me when you said the most innocent person in the world.
True, it happens. We have 300 and some convictions in the Innocence Project. That's just the tip of the iceberg, as we know.
Well, the DNA proves that they didn't do it.
Absolutely. Can't deny it.
Right. That is true. That is true.
We just had one in New York yesterday. 2 people who were proven to be innocent in a crime that actually never happened. It wasn't they were innocent, but the crime itself never happened. So it does happen in trials. Whether it happens in this one, we'll wait to see. We have a long way to go in judging
long way
the
to go.
evidence.
Yeah, that's right. This is just the opening. We're just getting this, by the way, viewers out here, it's sort of, it comes in, it takes a long time for this to come in. The prosecution has to lay this groundwork because the last thing that they want to happen is if they rest and they haven't laid the groundwork of getting this evidence in, because then they can argue this evidence at closing, and maybe, just maybe, the jury can be looking at this when they deliberate in the jury room. Not all judges will allow that. It depends on the jurisdiction, but sometimes the jury could be looking at it and just kind of going through it and looking at it when they're actually deliberating. But let's go back into the courtroom and see what's going on. We'll take another peek and then we'll come back to Linda and myself. Okay, it looks like the sheriff is coming off the stand now. My guess is they'll probably continue the afternoon with more law enforcement. It seems like that has been the MO for the day. Linda Badan in the Willis case. They're trying to get through all of the evidence. There is a lot of physical evidence that they just have to present to this jury so that they can argue it later at trial, don't you think?
Yeah, there is. And we just talked about that camera bag, and it turns out it was a whoops. The prosecutor just had the wrong picture in the PowerPoint. It's no big deal. So, sometimes you got to pick your spots if you're the defense when you're going through. But the jury has to see it all. They have to see 1, 2, 3, whatever, how many camera bags there are. They have to see it all. And it can be very boring, by the way, even for the jurors when they're first in that courtroom, just listening to laying the groundwork. But it'll get juicy later.
It'll get juicy, yeah, because here we have another witness is taking the stand. It looks like she's another law enforcement officer, and a big bag up there for her. It looks like she's going to be having to go through this bag as well and be lifting out things out of the bag. And that's how it's done. Because these officers have gone through, they've got all the evidence in front of them. Oh, looks like that one's taken away from her. So she'll get another bag of evidence to go through. And that's how it's done, because they have to be the custodian of record, or chain of evidence rules apply depending on what kind of evidence it is. And boy, if the defense, and you know this well, if the defense can get you on something like that, if they can break a chain of custody, anything to keep that darn evidence out, you're going to do it. And, people say, oh, it's just the, technical rules of the trial and all that, and they got away on a technicality. hey, you as a good defense lawyer, right, Linda, you're going to do whatever you can do.
Lise, it's important that it's the correct evidence that's being presented against your client. If the evidence somehow gets swapped, and it's happened in trials, it gets switched, it gets moved, then, you know, it's not good for the prosecution either. So you really want to preserve the sanctity of any trial to make sure the evidence that the jury is seeing is the evidence that pertains to that particular case.
Or if if it's truly bad evidence, or it's been swapped out, or if it's just been a little bit bungled.
Well, sometimes a little bit. You know, you can't really have a little bit bungled when you come to lab work. It's bungled
that's
or
true
not
too.
bungled. That's the
lab
issue.
work. Yeah, that's true. You can't be a little bit pregnant, I suppose. That's true. So this is going on to the Bletch case. It looks like they are talking about the Bletch case. It looks like here.
She's the other victim?
Yes, she was the victim before, and it looks like this witness is talking about that. So let's go in and listen online. Okay, very interesting here, Linda Badan. We've got this detective, Lisa Frere, on. She's saying that the eBay transaction she's talking about showed a receipt for the case found in Willis's van. So that makes the tie to everything that we've heard before that was brought into testimony, the receipt from his case into the van. So that makes sense now. Now here, this is really interesting to me, a 5-page printed list of U.S. serial killers was found in a camera bag in the shed.
Wow.
Okay, and there were hash marks next to 2 names on the list called the Toolbox Killers.
Wow, wow,
Whoa.
wow. Because we saw that thing that looked like a toolbox, but it was really a safe. All right. Keeping all those accoutrements, the insulin and all the chains and the handcuffs that's found under his seat that he's driving. So now we connected it to him. But now we have somebody researching and printing out serial killers.
Researching
and hashtagging the toolbox.
5-page and printing it out.
Oh, my gosh.
Not only, I mean, you got to think through, not only just like randomly, you know, oh, I'm in a bad mood, or I don't know, whatever.
Now, if you and I had that printed out, people would understand. We're lawyers.
Yeah, we're lawyers. We work for Law&Crime, so you know, we might do it.
We research that.
Yeah, we research it, but not only researching it, like putting it on here and like maybe taking a note. Oh, 5 top, but printing it out
and hashtagging
and then hashtagging it.
Does that mean that whoever was doing this, which the prosecution says is Willis, wanted to be known as the Toolbox Killer because he was keeping the toolbox, aka the safe
toolbox, right? With all the things we've heard about earlier in the case.
And that's what he wanted to be known as, as a serial killer.
Right.
I don't know the psychology behind it, but it's weirding me out a little bit.
Now the plot thickens here because we've had this, you know, very methodical testimony earlier this afternoon with these investigators taking the stand and going through the toolbox. It looks like a safe, we were calling it. We weren't really sure what to call it. And the investigators bringing this stuff out and going kind of like grossly through all of this stuff and chains and all this stuff we were learning about all this stuff. And now we're connecting the dots, connecting it to him with this investigator talking about the 5-page printed list of the U.S.
And the Bletch body is also intermingled with this investigator.
Yes, right, exactly.
That's the previous
very important,
homicide.
right, exactly, the previous homicide.
That the jury doesn't know he's convicted of, but we know he's convicted of.
Right. And she investigated both of these killers, or both of these victims. So she kind of, when she's testifying about them, she brings both of these investigations together. Boy, she's being asked about the Bletch case now in cross-examination.
Wow.
So let's hear about that. All right, it looks like that is the last witness for today in the Willis case in Michigan. Fascinating day. The investigators were on the stand, really bringing in so much evidence today. I have Kenney Badan with me for just a couple minutes. I want to just talk about a couple of points. In the last couple of witnesses there, we had one witness who tied in a receipt that the defendant had purchased, and a receipt that he had from the first victim and he purchased, I'm sorry, the second victim,
Right.
he purchased gasoline from her, and he had a receipt from that gasoline. He had that receipt by his bed. What do you take away from
Jessica,
that?
the victim here, whose body has never been found. I can't take any more.
Two things. One, the receipt is out of bed, and second thing, no body found.
It's amazing. That really tied it at the very end to to Willis and the evidence to him, the receipt. Who keeps a receipt by the bed of the person who's never been found, and the fact the body's never been found. That's why he's not pleading guilty.
That's why, exactly. We were sitting all why is he not pleading? Why isn't he just like, why is he going to trial on this? That's why there's no body found.
Like Jordan Vandersloot and Natalie
Hall, exactly.
Right.
He's hoping, he's going to trial because he thinks he can get this because there's no body found. Maybe he can convince a jury that he didn't do it. And he took the stand, don't forget, he took the stand in his first murder trial saying he didn't do it. So, pretty good bet he's going to take the stand in this trial, second murder trial, and hopefully he can get off by taking the stand. Lis Wiehl here. I had Kenney Badan with me this whole 2 hours. Thank you so much, Linda, for being with me. Great guest as always. And we'll be back tomorrow with more follow-up in the Willis case out of Michigan's great trial. See you tomorrow.